Good afternoon, everyone. My name is John Cornwell, and I'm Plunkett Cooney's Director of Marketing and Business Development. I have the pleasure of coordinating today's webinar, which is sponsored by our Governmental Law Practice Group. The Fourth Amendment of the U.S. Constitution is always an interesting topic because of the many nuanced issues it sparks, particularly as they relate to limits and protections placed on law enforcement when they conduct searches. We're fortunate to have with us today some of the firm's most experienced municipal attorneys, Audrey Forbush, Bob Callahan, and Rhonda Stowers. All of them have extensive experience working with law enforcement and dealing with issues related to the Fourth Amendment, including litigation that results from those disputes. Before we get started, I'd like to take just a few moments to provide you with some background about today's speakers and about our law firm. For those who don't know, Plunkett Cooney's based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 150 attorneys. We have offices throughout Michigan in 8 cities to be exact, and in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Plunkett Cooney's Governmental Law Practice Group now has about 20 attorneys. The group has expertise in such areas as election law, Freedom of Information and Open Meetings Act, labor and employment, police liability, zoning and land use, and many different areas. Today's webinar is actually designed to benefit law enforcement personnel, municipal officials, and insurance professionals. So with that, I'm going to introduce to you our speakers for today, Audrey Forbush, Bob Callahan, and Rhonda Stowers. Audrey is a member of Plunkett Cooney's Board of Directors, and she serves as managing partner of the firm's Flint, Michigan office. She's also the co-leader of the Governmental Law Practice Group. Audrey's recognized statewide as an expert in the area of police liability, and her municipal law practice is quite extensive and includes areas such as labor and employment law, public officials' errors and omissions, and other areas of liability. Bob Callahan is a partner in the firm's Kalamazoo office who concentrates his practice in the area of general civil litigation with an emphasis on municipal law, real estate, and labor and employment litigation. He currently serves as outside counsel to the Marcellus Area Emergency Services Association, which is a jointly owned municipal entity, and he has served as village attorney for the villages of Cassopolis and Marcellus in southwest Michigan. Rhonda is a senior trial attorney in the firm's Flint office who focuses her practice in the areas of general litigation and governmental law. She advises and defends her clients in claims involving the Freedom of Information Act, the Open Meetings Act, federal and state constitutional issues, civil rights, cannabis, which is a new and very popular area of the law since recreational and medical are now the law of the land in Michigan, ordinance drafting and enforcement. She also represents public sector clients in premises liability, employment law matters, product liability, and general litigation cases. So now just a couple of housekeeping notes for today's program. For the Q&A portion of our webinar, we're going to use the questions window on your GoToWebinar navigation display, or dashboard as we refer to it. Please take a moment now, if you can, to locate the window, the questions window, and feel free to type in questions as they occur to you during the program. We'll try to address as many questions as possible at the end, but I always add one caveat, and that simply is that keep those questions, if you can, to a more general nature. It's never a good idea to get too specific about your particular situations in a recorded environment like today, because we are recording today's webinar, and we want to respect everyone's privacy as best we can. So thanks again for attending today's webinar. Audrey, I believe you're up first, so go ahead and take it away.
Thanks, John. You know, this is a fun webinar, at least from my perspective, because it's a topic that we see on a regular basis. And that's what, when we're developing these webinars, we're looking at the trends, the types of cases that are being filed, the types of incidents that are causing us some consternation. And it's always very interesting to me, for instance, when we have a search of a home, when we initially meet with the officers, we've read their reports, and the first question I ask them is, okay, why are we here and how do we get in the house? And it's interesting the responses that we might get back, because some of them will be, well, because there was a crime going on. Okay. Did you have consent? Did you have a warrant? did you have exigent circumstances? And sometimes those questions are difficult, and the officers are not able to articulate the basis for the entry into the home or onto the property or into that backyard or into that garage where they can see perhaps evidence that they want to seize, or the searches of automobiles. And I think it's an important area that needs to be refreshed, because we do see a fair amount of cases involving illegal or alleged illegal entries into homes, onto certain properties, and into motor vehicles. And the officers need to be aware that there are certain limitations and circumstances that may limit where they can go and what they can look at and how they can search it. It's my pleasure to introduce the experts on these issues, because they're going to do all of the talking, so I'm happy about that. So I'll hand the matter over to Robert Callahan, who's going to cover some issues related to curtilage and the Fourth Amendment.
Good afternoon. I'm covering the curtilage and the Fourth Amendment, and I'd like to start out with what does the Fourth Amendment really protect? And that is set out explicitly within the text of the Fourth Amendment, that the rights that are protected, our rights, including the rights of everyone else, are to be secure in our persons, in our houses, in our papers, and in our effects. One can question how that has evolved or how it's been interpreted in today's day and age with the electronical advances, technological advances, and that is a very fascinating topic. But we're covering some more mundane topics today, and one is the curtilage of one's property, and where does that fall within the Fourth Amendment? And I take the approach of going through the basic Supreme Court history on this, and then I look ahead at where things stand in the Sixth Circuit. The first Supreme Court case that was dealing with the area around a house or dwelling and whether it was protected or not comes up in a 1924 case. It's Hester versus United States. And this was about the time period that Fourth Amendment jurisprudence was starting to be developed. And in Hester, the court held that the open fields around a house do not receive protection under the Fourth Amendment. It doesn't come within a person's houses, papers, or effects. As we jump forward into 1984, the United States Supreme Court had another case involving this. It was Oliver versus the United States. And that's when the Supreme Court coined this term curtilage of a house. The curtilage of a house is protected. And in order to come up with the curtilage doctrine, they relied on Old English law to come up with that term. And the extent of what is and is not the curtilage of a house depends on numerous factors. And those factors will bear upon whether the individual within the house has a reasonable expectation of privacy, that it would be an extension of the home itself. And I use this quote from Oliver because this is the central question that the Supreme Court has been grappling with, and that is whether the area at issue harbors the intimate activity associated with the sanctity of a man's home and the privacies of life. And those are pretty value-laden terms: intimate activity, privacies of life, and a man's home. So they're talking about areas that really are central to our home life and our privacy. The next Supreme Court case that dealt with this curtilage issue was United States versus Dunn. And that's an interesting case. It comes up from down in Texas, somewhere deep down in the heart of it. And what it involved was a search of a barn where the police officers found growing equipment, marijuana. And the barn was located about 50 yards from the fence surrounding a ranch home. And this was on a ranch. It was on a couple hundred acres. And there was a large perimeter fence around the ranch and then numerous fences throughout the area. And the police officers, acting on a tip, went and looked into the barn. The barn had a fabric that was preventing a plain view of inside it, but the officers looked inside it, saw the equipment, and importantly, what they did then is they went and got a search warrant so that they could search the whole area. The criminal defendants said that that was a violation of their Fourth Amendment because they had a reasonable expectation of privacy in that barn. That the court looked at the factors that it was not within a central fence that would have been close to the house. It was 50 yards away. You had drug activity going on there that would not be normally associated with privacy inside a house. So the court held that that was not part of the curtilage. The next case we have involved in the curtilage doctrine is Florida versus Jardines. This gets into, I think, the most important part of it in the recent history, and that was a case where the police used a drug sniffing dog, took it onto the front porch of a person's house, and the dog was sniffing for whether there were drugs inside. There were drugs inside. And it was contested, saying that that was a warrantless search and in violation of the Fourth Amendment. The court reiterated that the curtilage is an area around the home, this is in quotes again, intimately linked to the home, both physically and psychologically, and is where privacy expectations are most heightened. And this was an issue that was an opinion that was authored by Justice Scalia, and he gave really good bright line guidance in Jardines when he wrote, "The front porch is the classic exemplar of an area adjacent to the home and to which the activity of home life extends." He also went on to talk about whether police officers, law enforcement officers can go onto a porch. Now, in this case, they stayed on the porch way too long and had the dog in there looking. But he wrote that law enforcement officers have an implicit license to approach the house by the front path, to knock promptly, and to briefly wait to be received. And he analogized what those actions would be to what people do in real life. And God bless Justice Scalia is not with us anymore, but he used this language in the bullet point. Complying with terms of that tradition does not require fine-grained legal knowledge. It is generally managed without incident by the nation's Girl Scouts and trick-or-treaters. I loved Scalia's writing, but the Jardines case provides some really good bright line type of law that we can all utilize. The next Supreme Court case dealing with the curtilage was Collins v. Virginia, and that was a 2018 case. And in that case, it dealt with the issue whether the automobile exception to the Fourth Amendment permits a police officer to come onto a person's property without consent or invitation, without a warrant to search a parked vehicle. Now, in that case, you had reports of a motorcycle being stolen. Police officers saw what they believed to be the stolen motorcycle at Collins's house, and it was parked at the top of the driveway. It was behind the front perimeter of the house, and it was enclosed. On two sides, it was enclosed by a brick wall that was car height. It wasn't enclosed on top, but then on the third side, it was enclosed by the house. It was right next to the house, and the police officer went past the corner of the house and took the tarp off of the motorcycle, checked the license plate, checked the VIN number, took photographs, and then on that basis went and got the warrant. And the Supreme Court held that this was a warrantless intrusion into the curtilage of the house. The area was closely adjacent to the home, and what they said was it was an area adjacent to the home and to which the activity of the home extended, both physically and psychologically, and where privacy expectations are most heightened. And it stands to reason. The closer someone is to your home, the more they are likely to be intruding upon what you consider to be your privacy interests. Now, this brings us to some recent cases. One was Sixth Circuit in 2008, and this dealt with a county in Ohio. They had what was called SCRAP, which was a Street Crime Reduction and Apprehension Program. And they had a standard practice associated with their knock and talk protocol. And their standard practice was to get a law enforcement officer from SCRAP on each of the four corners of the house. And then one officer, the fifth one, would go up to the front door and knock at the door. And each of the officers that were at the corners were about 5 to 7 feet from the house. So they went to the house at issue based upon a tip, knocked on the house. They were not let in, but one of the officers said, "Hey, I think I see some marijuana up on the deck on top," and based upon that, they got the warrant and sought the search. So the issue was whether forming the perimeter on the house on the way they did intruded upon the curtilage of the plaintiffs. And factors that the court took into consideration, this is the Sixth Circuit now, was that the plaintiff had on the front window of the house and on the vehicles that were parked in the driveway or the yard or whatever, they said no trespassing. The house itself was located pretty far away from the neighbors, about 300 feet away on each side. There were limited sight lines that people could have to look into their backyard or their house. And there were no residents across the street or behind their house. So this was a pretty secluded area. The court held that the officers in this case intruded upon the curtilage of the house. The 5 to 7 feet from the house easily was within arm's length of the house. The Sixth Circuit quoted, "Easily understood that the arm length from the house is a classic exemplar of an area adjacent to the home and to which the activity of home life extends. That's the exact same language that Justice Scalia was using in the Jardines case. The Sixth Circuit also stated that the law was unambiguous that a backyard abutting the home constitutes curtilage and receives constitutional protection. These are pretty strong statements that I think need to be made note of and would make it very difficult for us to argue that there'd be qualified immunity if we had situations where law enforcement were intruding into those areas absent a warrant or some type of exigent circumstances or consent of the owner. And then we have the United States versus Coleman case, and this can be juxtaposed against the Morgan case. This was a case where the criminal defendant was challenging evidence that was obtained by tracking devices placed upon his car in the driveway of a condominium, and a car that was his car was parked across the street. And he asserted that the car in the driveway of the condominium where he lived was within the curtilage, and he was trying to bring that into the context of the Supreme Court case in Collins, but the facts were very different. The condominium where the defendant in Coleman was composed of approximately 40 residential units. Each residential unit had more than one condominium unit within it. It was a gated, well, it was a fenced around there, but there was no gate or fence at the entrance to the condominium that said no trespassing. There was no forbidding of visitors to come into the condominium, and residents of the condominium could have visitors in without requiring permission of other individuals. So you have people that could come in and out, and that certainly diminishes a person's expectation of privacy within the general condominium area. The criminal defendants lived in a building. There were 3 other families, and importantly, his driveway was shared with a neighboring family, and there were no fences, hedgerows, trees, things of that nature that shielded or blocked other people from looking into the yard, the driveway, etc. The Sixth Circuit held that under these circumstances, that criminal defendant did not have a reasonable expectation of privacy in the common area of the condominium that was unlocked and open to the public. So these courts have come up with 4 factors that it analyzes to determine whether an area at issue is within the curtilage of the house. The first one is the proximity of the area claimed to be curtilage to the home itself. We have the one case where you have the law enforcement officer stationed 5 to 7 feet from the house. That is way too close. You have the case in Dunn where the barn was 50 yards away from the house. That was not curtilage. So the farther away from the house itself, law enforcement officers intrude upon. In other words, the closer they get, the more likely it is going to be considered to be curtilage. The next factor is the area within an enclosure surrounding the house. If someone encloses an area around the house that exhibits an expectation of privacy that that area within the enclosure will not be intruded upon. Now, if they enclose a really large area, such as the enclosure in Oliver, which was acres, that's not an area that society would expect to be legitimate expectation of privacy. But if it's a relatively close area that's being enclosed, that's going to be more likely to be considered curtilage. And then the nature of the use to which the area is put. If you have the family backyard activities, you have swing sets with kids, things of that nature, it's going to be more likely to be considered an area where there's a reasonable expectation of privacy. And then finally, the steps taken by the resident to protect areas from observation by people passing by. So the takeaway here is the identification of whether something is curtilage or not. It's fact intensive, using the factors of the proximity of the area to the house, whether there's an enclosure, the use of the area, and the steps taken to protect. And as we now know, areas that are included within the curtilage, front porches, areas within a very close proximity to the house, how far away you can get to the house before you are within the curtilage is an issue, backyards, and then look for areas of fencing, enclosures, etc. Now, we've already talked a little bit about the knock and talk issues. Now, knock and talk is a tactic which is used by law enforcement. What is done is a police officer comes to the front door, knocks on the door, and attempts to engage the individual who answers in a conversation. The court in Florida versus Jardines that we previously referred to, it held that that is not an unreasonable warrantless search. And the Sixth Circuit in United States versus Thomas has recognized that knock and talk tactics are a legitimate law enforcement investigative technique. Now, everyone doesn't share the feeling about knock and talks. A very recent case by a federal judge in the Eastern District of Michigan, United States versus Mills, talked about abuses that arise through the knock and talk technique. And in a footnote here, this was, I forget which judge it was, but he was appointed by Obama, noted in a footnote, knock and talk investigative technique has been noted by courts to be, quote, easily subject to abuse and has received its fair share of criticism. And this court did that in a footnote and selectively put in some courts that have been critical of law enforcement during knock and talks. And problems arise when a knock and talk goes too far and can be considered to no longer be consensual. And that United States versus Mills case is illustrative of that. The facts in that case were there was a search warrant being executed on apartment number 8 in an apartment complex. The two detectives were told by their commander to go perform a knock and talk at an adjoining apartment number 4. While this was going on, apartment number 8 was being searched, and there were numerous SWAT team members in the parking lot outside. So the law enforcement officers did the first knock and talk. They testified during the evidentiary hearing that they performed the knock and talk with presence. And the officer testified, we want to know that we that we are here. We'd like to come to the door. It's the police. We'd like to come to the door. The criminal defendant testified that it was a really loud, intimidating kind of knock. But what the police officers did, they knocked with presence, and then they remained at the door for 2 to 3 minutes. It could be argued that perhaps 2 to 3 minutes is too long to be waiting in the first instance. But what they did then is they went back to apartment number 8, stood outside in the hallway, and then 10 minutes later they went and knocked on the door at apartment number 4 with presence. Eventually the people came out to leave the apartment complex. The officers separated them and asked them questions separately and got information that they believed gave them probable cause to enter the apartment. They found evidence, and then you had the suppression hearing. The court held a lot of things. There are a lot of issues in this case, but for the purpose of our discussion today, it held that the initial encounter between the individuals and the police from that knock and talk procedure was non-consensual and therefore was a seizure. And it stated a police officer's attempt to perform knock and talk may become coercive and exceed the scope of a consensual encounter if the officer asserts his or her authority, refuses to leave, or otherwise makes the people inside feel that they cannot refuse to open up. And the court talked about the overbearing tactics used by the police officers in that case. Those tactics included that use of authority that led the criminal defendants to believe that, to reasonably believe that they had no choice to comply. There was the threatening presence of several officers at the scene. There was the display of a weapon by the officer. There was some physical touching of the person by an officer. And then the use of language or tone of voice indicating that compliance was required. It was not an issue. This court was exceedingly critical of the police officers' tactics. And it was interesting that the judge in this case contrasted the actions by the police officers with a Ninth Circuit case. Now, Ninth Circuit is pretty well known as being relatively liberal. In the Ninth Circuit case, it was United States v. Crapser. I love that name, but the court characterized the police officer's actions as, quote, a single polite knock on the door. The officers asked the occupant to open the door. No demand was made to open the door, and there was no affirmative assertion of authority. As opposed to that case in Mills, the court said that once the police officers had not been responded to on the first knock, they should have retreated and not attempted a second knock and talk. The second knock and talk transformed it into a non-consensual seizure. And in the footnote, the court in United States versus Mills stated, quote, this case illustrates why the concerns about the improper use of and execution of knock and talk encounters are justified, close quote. So the takeaway on this is that entering onto a porch to perform a knock and talk is not an unreasonable intrusion onto the curtilage of a house. However, you cannot overextend your stay. You need to be professional, polite, don't take actions which could become overbearing on the individuals. And if they don't respond, don't stay on the porch too long. You made your attempt. They have the right to not respond to an officer knocking at their door. If they really want to talk to the people or search the house and they have probable cause to do so, go get the warrant or get more evidence that would support a warrant. Which brings us to the issue of consent. Consent is one of the exceptions to the warrant requirement of the Fourth Amendment. A warrantless search is reasonable if it is based upon the consent of an individual. However, consent to search, it needs to be unequivocal, it needs to be specific, and it needs to be intelligently given and uncontaminated by any duress or coercion by the police. And that comes from a Sixth Circuit case from 2011, United States versus Beauchamp. So in determining whether consent has been freely given, the court will look at the person giving the consent. And this comes from a recent case, Harris versus Clare, the characteristics of the consenter. And that includes the age of the individual. The younger the age of the individual, below 18, the less likely will find that it was free and voluntary. The intelligence and educational level of the consenter, and whether the consenter understood the right to refuse to consent and his or her constitutional rights. The factors determining whether there has been coercion, they include the nature and length of the detention before the consent was given, the use of coercive or punishing conduct by the police, or more subtle forms of coercion that might flaw the judgment of the individual. If someone does give consent after an illegal search had been made, it can still be tainted and invalid. However, assuming that there had been an initial illegal seizure, consent to search at some later point in time can be deemed to be appropriate because of the attenuation between the time and the consent that was given. But the court's going to look at various factors, and that is the length of time between the initial seizure and the consent, the presence of intervening circumstances which would show that a person understood what they were doing when consenting and they did it out of their own free accord. The court will look at the flagrancy of misconduct by police officers, and from Beauchamp, whether the suspect was read his or her Miranda rights before that person consented. So I'm going to be turning this over to Rhonda now, where she can talk about automobile searches and the Fourth Amendment.
Thanks, Bob. As we indicated at the beginning, it's important to keep in mind back in 1967, the Supreme Court and Justice Stewart of that court said that the Fourth Amendment protects people, not places. And as Bob indicated, it is a protection of people to be secure in their persons, houses, papers, and effects. And one of those effects of a person the courts have held is the automobile. So a citizen does not surrender all of their protections under the Fourth Amendment when they enter their car. However, there is no Fourth Amendment violation unless the person has a reasonable expectation of privacy. And in making that determination, the courts look to two things. First of all, is there a legitimate expectation of privacy with respect to the particular issue at hand? And secondly, is that an expectation that society is prepared to recognize as reasonable? Now, when you're looking at a car, the Supreme Court has said, look, the way that the character and the use of an automobile suggests that there's a lower expectation of privacy. First of all, its function is transportation. It's not usually, or is seldom, hopefully, used as a residence. It's also not usually a repository or a place where people keep their personal effects. I think the court that ruled that has never seen the inside of my car. It travels on public roads, it's in public places, it's out there, its contents and its occupants are in plain view. And that's especially true of Michigan. Michigan has a window tint law that people have been trying to change for quite some time, but MCL 257709 provides that the front windshield and the side windows immediately adjacent to the driver and passenger, and the little side wing windows, back for vehicles that had them, in front of those windows cannot have any window tint except for the top 4 inches. So in terms of Michigan in particular, you're out there, you're in plain view when you're out on the roads. And then finally, there's a lot of governmental regulation and control that happens with regard to vehicles. There's licensing requirements, there's inspections, there's certain criteria that your car has to make. So every operator of a motor vehicle must expect that the state, in enforcing those regulations, will intrude to some extent on privacy. So for that reason, the courts have developed what is known as the motor vehicle exception, which is an exception that the law enforcement may search a vehicle without a warrant if they have probable cause to believe that the vehicle contains evidence of a crime. And this is true and applies even if there is time and opportunity to actually get a warrant. And when the court's looking at these circumstances, it's a common sense review. It assumes the totality of the circumstances. It takes into account officers' training, officers' experience, all of the information known, and maybe not even to the particular officer doing the search, but the collective knowledge of all of the officers who are involved. So there's not necessarily a need for consent if there's probable cause. But there are a few circumstances where you may want to attempt consent anyway. First of all, it tends to be simpler, it tends to be faster, it's less burdensome. You just walk up, and if you have consent, then you're not having to worry about what you can search, what you can't search. It eliminates those questions of, okay, this is locked and it's in the back seat. Is it within his reach? Do I have an exception? You don't have to worry about all of that. You can just go ahead and search. And it also likely doesn't hurt. When you ask for consent, you are not forfeiting probable cause. Now, obviously there's a concern that if this person is told, okay, can I search your vehicle? And they say no, and you say, well, I'm going to do it anyway. Obviously, that's maybe not go over well with the person that's involved. But legally, you would be on firm ground to do that. So talking about an initial stop. In terms of the Fourth Amendment, an officer, in order to stop the vehicle in the first place and make a traffic stop, there either has to be probable cause of a civil infraction or reasonable suspicion of criminal activity. And again, this is based on the totality of the circumstances and the knowledge available to the officer who's drawing on their training and their experience. I had a case back in the day where, and I always like to argue this, there was a case where an officer pulled over an individual and they were challenging the validity of the stop. And in arguing that case, I found a Court of Appeals case which was unpublished, but the vehicle was swerving inside the lanes but never actually violated any traffic laws. And this was back prior to the United States versus Lyons case, but at that time, the court held that an officer's training and experience watching that vehicle swerve, even though they weren't necessarily violating traffic laws, gave them a reasonable suspicion to pull over the car and stop it. Now you need probable cause for a civil infraction or reasonable suspicion for criminal activity. Probable cause has been defined as reasonable grounds for belief supported by less than prima facie proof, meaning, obviously you're not working with the criminal standard of beyond a reasonable doubt, but you have to have more than just a hunch, more than just a mere suspicion. It has to be fairly strong. Furtive behavior in and of itself is not probable cause. Now, if that's coupled with other activity, if you have a driver who is reaching behind them, for example, merely reaching behind maybe not be enough, but if they have something in their hand and now, okay, maybe I saw something black, maybe it's a gun. That occurred in People versus Jones, which was a Michigan Court of Appeals case in 2019, and the court held that that was sufficient to constitute probable cause. The other issue that comes up a lot is the smell of marijuana. And Bob talked about in some of his cases, they looked through the windows and they saw marijuana plants. And that now is that's come under fire, and that's possibly no longer a reason for probable cause. Because keep in mind, the idea is that you have probable cause of criminal activity. But now that we have medical marijuana and recreational marijuana, the mere presence of marijuana may not be sufficient to have that kind of impact. You're not necessarily looking at probable cause of a crime at that point because it's legal to possess to a certain extent. And for this reason, the Michigan State Police have even come out and said that they are not going to rely solely on a dog sniff or solely on the smell of marijuana to search a vehicle. And that creates additional problems too, because a lot of canine units are trained to detect not only other drugs, but the presence of marijuana. And now you have to call into question maybe those dogs and their training to see if you can break out other drugs from marijuana in order to uphold a search and probable cause. So the reasonable suspicion that I mentioned earlier to pull over a car, obviously more than a mere hunch again, but it's less than probable cause, and it's even less than preponderance of the evidence, which is a standard of, that feather's weight, that 51 versus 49%, that little tip of the scale. Now, your intrusion has to be reasonably related to the scope of the situation. This came up in a Supreme Court case, Rodriguez, back in 2015, where a person had been pulled over, they did their stop, they had issued a citation, and then they held him because they thought there might be drugs in the car, and they had a canine come and do a sniff. The canine alerted on the vehicle, and then they proceeded to search the vehicle and find drugs. And the court ruled that that was improper. It was an intrusion that delayed the stop unreasonably, and it was unreasonable under the Fourth Amendment. So once the vehicle is stopped, you are allowed to ask questions unrelated to the stop. You're allowed to chat, you're allowed to do other inquiries, as long as I mentioned before, you're not measurably extending the detention beyond the mission of the initial stop, and also if the responses are voluntary. You also have the ability to order the driver out of the vehicle. Even without a reason to be suspicious, an officer is allowed to order a driver out of the vehicle during a stop to ensure their own safety during the encounter. And as we'll talk about in a few minutes, that also includes searching the immediate area available to the driver, which can include the passenger area. You also have the ability to search locked containers inside the car for the most part. And this was a case, Carter versus Paris. There used to be a distinction between a car and the contents of the vehicle, and that's gone away. Right now, so long as there's probable cause to justify the search of a lawfully stopped vehicle, it justifies the search of every part of that vehicle and its contents. Now, there is a caveat to this, and there has to be reason to believe that there's evidence in the location being searched. And Carter versus Paris gave the example of Pappy Van Winkle bourbon, which is apparently a very rare and expensive bourbon. And if there was a barrel of that, you couldn't look for a stolen barrel of Pappy Van Winkle bourbon in the glove box. That wouldn't give you a basis to search the glove box. But where that barrel might fit, those are places that would be available to search, as long as you had probable cause. You also have the ability to delay the search after the arrest until you get back to the station. This was a case, United States versus Bullock. This is another 2019 case where the officers had pulled over the car. There was probable cause to search. In the course of searching the vehicle, it began to rain, and the rain prevented further search. So they took it back to the police station and continued the search there. And the defendant in that case argued that the police should have gotten either additional warrants or probable cause in order to continue the search at that point. And the court said no. If probable cause exists at the time, that doesn't change just because of a delay. You still have the probable cause. You can also perform an inventory search. These are intended to protect property that's in the custody of the police and prevent claims against the police about what may have been in the car. Nobody owns a Picasso until their car goes into impound, and then suddenly this rare Picasso is missing from their vehicle. So these searches are performed in order to protect both the person and the law enforcement from claims against each other of either additions or subtractions from the car. There are some limitations on this. It's only allowed when the vehicle is lawfully in police custody. It requires it to be conducted pursuant to standard police procedures. And there's cases where they've opened a locked trunk and looked in the trunk and found where they actually removed the side panel once they'd opened the trunk, and they're looking in the side panels and they're finding contraband. And the court said that's way beyond a standard inventory search. It wasn't part of their usual protocol. It was outside of just looking in the trunk to make sure all of the contents in the trunk had been ordered. So the court found that that was impermissible, and there should have been a warrant for that activity. And it also can't be solely for the purposes of investigation. It needs to follow the procedures, the protocols, and have the purpose of being for inventory. Looking briefly at passengers. Passengers can also be ordered to step out of the vehicle. This again goes to officer safety. Officers are allowed to move people out of the vehicle, control the scene, and make sure that they are protected while they are performing their law enforcement functions. Passengers also typically do not have an expectation of privacy. So if the driver gives consent or there's probable cause based on the driver's conduct or something that the officer's seen, a passenger can object to an officer checking a trunk or checking the glove box or looking under the seat. However, if the passenger has an expectation of privacy as to their belongings, they can object to their belongings being searched, even if the driver consents. And I mentioned earlier about searches incident to a lawful arrest. Again, it's intended for officer safety and evidence preservation. It doesn't require that there is an actual formal arrest, but it does need, and a formal arrest needs to follow quickly on the heels. And you can't be searching just to get evidence in order to then establish probable cause. You have to have probable cause before you start performing the search. Searches incident to lawful arrest are limited in scope in that it needs to be within the reaching distance of the person being arrested, or there has to be reason to believe that the vehicle or the container involved contains evidence of an offense of an arrest. And then finally, with regard to trespass claims, these are The chalking tires is something that's just come up just in the last few months in the Sixth Circuit. And it was an issue where the city of Saginaw was chalking tires in order to determine whether or not individuals were properly moving their cars or were exceeding the 2-hour parking limit with regard to those meters. And the court was asked to look at it. This woman had 15 different parking tickets and was complaining that they violated her Fourth Amendment rights by marking her tires. And the court, in looking at it, said that it was in fact a search, that the officers had trespassed upon a constitutionally protected area in order to obtain information. And that's the standard there. And it's the same standard that applies in GPS tracking of vehicles through a device that's attached to the car. In fact, the Taylor versus City of Saginaw case relied very heavily on the prior Jones case, where the officers had attached a GPS device to a vehicle. And the courts have held that by attaching things to the car, even if it causes no permanent damage, that's a physical intrusion. And the physical intrusion is what causes the constitutional issue, because you're doing that and you're doing it in order to obtain information. In order to do that, you need to have a warrant. And we are almost at 1 o'clock.
Okay, thanks very much. Yep, Audrey, go ahead. I was going to jump in on Q&A.
Go ahead, John. I was just going to see if there were any questions, and I'm assuming you probably have those if there are.
I can tell you that. Just as a reminder, before we do have 2 questions right now. So if you would like to ask a question, again, just locate the questions window in your GoToWebinar display and type it in. And then we'll get to those in a second. We have 2. So I will start with the first one, which is, if an officer sees a minor drinking in a home and they're clearly underage but won't come to the door, can officers step into the foyer of the home? I don't know who wants to take that one.
Well, they cannot if they don't have consent. They can knock at the door, like the curtilage issues. They can go onto the porch, ask to speak to people there, but they cannot just enter the home, cross the threshold from the porch into the home. They have probable cause that something wrong is going on in there, but they cannot just enter in without a warrant. There's no exigent circumstances that would justify that.
Okay, great. We have one other question at this point, so feel free to type in your questions now. If not, we'll wrap things up. But the second question I have here is, if there is a car at the end of a driveway, is that in a public or private area for purposes of the Fourth Amendment?
I actually had a case like this where I had a car. Mine was actually parked partly on the public sidewalk, which obviated the issue in my case. But in looking at that, in doing research, the court has held that a car at the end of a driveway closer to the road, more where general public could be or be present, is not considered in a private place, at least for Fourth Amendment purposes. Bob, did you have a different feel, or?
No, as I interpret the question, it would be at the end of the driveway that would be closest to the street. And the analysis comes down to, well, first of all, I assume it's not real close to the house either, which would get within the a question as to whether it's 5 to 7 or a little bit further away from the house for curtilage purposes. But if the officer was walking by the house to otherwise get onto the porch, but if the car is where the public would be able to see it in any event and it's readily accessible to the public, then it would not come. It would not be private at that point.
Okay, great. Thank you for that. Well, I don't see any other questions in the queue right now, so we're right at our time anyway, so it's good timing. Before we wrap up then, want to mention real quickly that once we conclude, you'll receive a survey from us. We hope you can take just a couple of minutes to complete that. We don't make them particularly long. One of the most important parts of that are topic suggestions you may have for future webinars. So please, if you have them, please provide them, and we take those to heart and try to use them down the road. In case you or a colleague would like to review this session again, it'll be recorded on our website. There's an event page for this particular webinar. Look for that event, and at the bottom of it, we'll have our slide deck once again in PDF format. We'll also have a recording. We try to get those done hopefully within about 24 hours if things work out well. So if a colleague missed this session, feel free to send that link to them or her, and they'll enjoy hopefully the program, which covered a lot of really good information. So at this point, this concludes our webinar for today. So on behalf of Bob, Audrey, and Rhonda, and all the members of our Governmental Law Practice Group, thanks again for attending, and have a great afternoon.